Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, I am going to tell you the recent US Supreme Court judgment on the admission process in the most famous Harvard and also University of North Carolina, Harvard University and also UNC. Honorable Supreme Court of United States, with a majority of 6-3, 6-3, held that race-based action in admission process is highly unconstitutional. It is against to the 14th Amendment of the American Constitution. Right. So, you can read the case as Students for Fair Admission, SFFA, Students for Fair Admission, INC, versus President and Fellows of the Harvard College. The decision was given on 29th June 2023. Right. So, already there are 3 dissenting judges, but majority of them held that the so-called race-based admission is highly unconstitutional. It is against to the Equal Protection Act, which is the 4th Amendment of the American Constitution. Before that, let us have a brief discussion on the admission process of the Harvard University, Harvard College, and University and its affiliated colleges, as well as the University of North Carolina. My grandson, Mr. Pranit, he studied in UNC, University of North Carolina. Presently, he is working in, already has prosecuted his degree from Chapel Hill branch. Right. So, normally, whenever you file an application for the Harvard College or Harvard University, there will be a 40-point pro forma and 40 members will scrutinize the application. The first reader, what he does is, normally, it is a highly selective admission process. He will grade in the number 1, grade which he attend. So maybe A grade, B grade or C grade. Second, recommendation letter. Some people, the billionaires or billionaires, normally, since they are the donors of the Harvard University, normally their recommendation letter will have a major value. Even though you do not get the enough grade, recommendation letter is another criteria. Third is extracurricular activities. Certain people may not be excelling in studies, but they excel in extracurricular activities like jumping, throw ball, games, computer, not so many things. That's also will be taken into consideration. And lastly, the race. Just like our caste here, race, it also, they have to allot seats to certain Americans, then non-Americans, Asians, East Asians, Africans, like that. So, color is also taking a part of the process of admission. I need not repeat the process endorsed by, the process utilized by the University of North Carolina, because they also follow the same process. Now the issue is, the point for consideration or the question is whether the admission system of giving admissions basing on race, whether it is lawful or not as per the equal protection clause of the 14th Amendment. So majority of the judges, majority of the jury, they agreed with the Students for Fair Admission with the association and held that the impugned admission policies of the Harvard and UNC, they amounted to race-based discrimination. Finish. Race-based discrimination. Right. So, please remember, Chief Justice here, the Chief Justice John Roberts, he stated that many institutions, not only Harvard and UNC, many institutions, they are wrongly concluding that an individual's identity is based on the color of the skin. No. At the same time, the judges stated that, please remember, the universities are involving the race in a negative manner, but nothing prohibits the universities considering an applicant's discussion as to how, please remember, as to how the race affected his life, because certain people, they are being demoralized or seen in a low level basing on their race. Yes, they have to be uplifted. Is it not? For example, so okay, let us take that they wanted to take Asians. So there are Southeast Asians, East Asians, Central Asians. They simply call them as Hispanic and give them seats. So this is not fair. So to sum up, the Honorable Supreme Court of United States held that the race-based admissions are not correct. And immediately, it was after the judgment, very recently, just 3 days back, the judgment has come. So the President POTUS, the President of the United States, Joe Biden, he strongly condemned the decision. Of course, he disagreed. We can't say condemned. He disagreed with the decision of the Supreme Court, stating that Harvard, they are very age-old institutions. They follow their own procedure because university have got their own law. Likewise, Kamala Harris, the Vice President, she also replied in the negative affirmative manner. But whatever it is, when the judgment comes, definitely they have to abide, because the judgment is taking a reliance on the precedents like Brown versus Board of Education, Topeka. All the judgments have been cited in this particular judgment. Anyway, so here the main point is the so-called race-based action in admissions is totally against to the Equal Protection Clause, which is the 4th Amendment of the American Constitution. So please read the judgment and enrich your legal knowledge. With this, I am concluding. Thank you very much.